nobody's deliberately trying to short you on your non-pizza lunch. That it's coming real soon now, and I want it too. So so I think what will happen is that when it arrives, maybe we'll do that, and then we can either the time for a break, or more likely we'll just kind of have people try to grab it unobtrusively. But I don't want to delay the start of this. I'm just so delighted to have Josh here. Yeah. He's gotten involved in this fascinating litigation, which has all these dimensions, some of which, as we're saying, are not the sort of thing that you really want to inflict on law students, just a little too Fed courtsy, if you know what I mean. But a lot of them, all of them are very interesting. Some of them are very high profile and charismatic. And behind them, there are a lot of interesting policy questions as well as legal questions. So Josh, why don't you just start by telling us, kind of give us a 5-minute summary of the big picture, and then we'll talk some more. I want to know also about how you got involved in this. Sure. And you're still a young man, a young professor. Kind of, it's an interesting thing about how you got involved at this stage of your career. Sure. And then maybe I'll prod you with a few substantive questions as well. So tell us some more about this.
Well, thank you, Eugene. It's a pleasure to be here at UCLA. Back in 2013, Cody Wilson was a law student at UT Austin. He was a 1L, like many of you. But instead of studying for class, he decided to take up a hobby. And he found a way of designing a computer file that can be used to manufacture the parts to make a firearm and different firearm components. He made international headlines. He put these files on the internet. This was shortly after the Newtown mass killing, which you probably recall. At that time, the Obama administration said to let's find all of our tools we have to try and stop guns. And Cody got a letter from the State Department. And the State Department said that you are in violation of export control laws for putting these computer files on the internet such that foreigners can download them. Now, Cody didn't even know this was even a crime, so he actually took the files down. What you probably don't know is that he then started to make arrangements to request a license from the government to put these files on the internet. He made this request. The government never actually did anything about it. The file just, the application just sat there. Around the same time, I wrote an article for Law Review, in the Tennessee Law Review. Professor Glenn Reynolds, who's a professor there at Instapundit, you probably know him better, he invited me to write about the Second Amendment and said, okay, I want to write about this new thing about 3D printed guns. And I wrote a piece saying that these sorts of federal laws have not only Second Amendment implications, but also First Amendment implications, that you're telling someone you can't put some information onto the internet. Okay, about 6 months later, I got an email out of the blue from Cody Wilson. He said, Josh, I want you to be my lawyer. I'm like, what? He says, I want you to help me sue the government. I'm like, what, are you insane? I didn't believe him, but, we talked about it. And after about a good hour, I realized, wow, he actually has his stuff together. He actually is going to make this a serious case. It's not some sort of, scam. And I said, I'm on board. Then I helped recruit Alan Gura, who was our lawyer for some time. He's not in the case anymore. And we challenged, what was that? Oh, well, you'll see Alan, he was in the case, not anymore. So we spent about 2 years suing the State Department, challenging this federal restraint. We lost the district court. We got divided Fifth Circuit opinion. We lost en banc by a couple votes in the Fifth Circuit. Cert was denied. Went back to the trial court. I'm condensing a lot right now. After we went to the trial court, the State Department decided to actually engage in settlement discussions. And we thought, good. They were probably going to lose, and they knew it because the Fifth Circuit has changed a bit since what it was before, and you can kind of count the votes. Not always a good approximation, but they had a good chance of losing on a summary judgment motion. So they settled with us. Didn't work, though. A district judge in Seattle entered an injunction blocking our settlement, and I actually argued that one. I had to argue in a crazy period, 4 TROs in 5 days in district courts. We got sued all over the country. It was crazy. But eventually the judge in Washington entered a nationwide injunction, blocked our settlement, and here we are today. So now we are simultaneously fighting in Washington, in Pennsylvania, in New Jersey, in Texas. I can't remember all the different courts, but there are a lot of them. And we've also gone on offense, and we've sued several state attorneys general including New Jersey, who have tried to enact laws that restrict our activities. I think it's 5 minutes. And if you guys want to get food, want to take
So
a,
why don't we
yeah.
take a very quick break?
Yeah,
to
go
grab
get
some
your
food,
chicken.
And then as you eat.
Yeah, we'll talk.
Oh, wow. I was
Sure.
thinking it'd be sandwiches.
No, this is good. You can do
Good stuff, but this is the real
And
thing.
Chick-fil-A sauce is fantastic.
Yum, I never had it.
It's legendary.
All right.
Please just sign in before you grab food.
Whoa, look at that. Sign in before you grab food. That's how it works at FedSoc. No free riding here.
Right, exactly.
Thank you, guys.
Sign up for the minor,
Okay. Napkins, do we have napkins?
Yeah.
No napkins?
guys.
No napkins. No, we eat with our hands. Well, I am eating with my hands, but I just want a napkin. It doesn't matter.
Okay, and
Tasty chicken.
tasty. The sauce is a little tangy, but it's good.
All right. Why the but? Maybe it's good.
I like the honey mustard sauce personally.
They have some honey mustard sauce. I'll get you some.
No, it's okay. Don't worry about it. No, it's fine. This is good. We can start. We can keep the conversation going. What are you doing?
Yeah, this is delicious.
It is. You come on two sides. Much quicker.
Yeah, absolutely.
Critical thinking.
I do a lot of these.
I have been known to just like talks I give just before the talk I pull the
I do
table
the
away
same.
from the wall
I do the same.
because I don't know
It
why
do-
they set it up this way.
It doubles the speed at which you
Exactly.
can get food. I do the
Exactly right.
all FedSoc. Pull the table away from the wall, double side.
Right, right.
Hey, what's that? So you learn the tricks.
I am the very model of the officious intermeddler.
The officious or efficient?
Sometimes both.
Okay, I think we have a critical mass.
We do.
Okay.
But I still want napkins. So you have napkins? Good, good.
Yeah,
Uh,
there's some salad as well.
Salad.
no, the salad.
Okay.
Are the forks to go with salad?
Thank you, sir.
Okay.
All right, let's resume.
So
Okay.
let's resume. That's the procedural posture. So you've got a First Amendment challenge, and you've got a Commerce Clause challenge, right? As
yeah.
to some of the state ones. Tell us first about the Commerce Clause challenge, and then tell us about the First Amendment one.
Okay. So you may have studied in con law the so-called dormant commerce clause, right? It's not actually in the Constitution, but the court has said it is. It's the idea that, sorry, eating while speaking. The court has said that one state cannot regulate. Fine. No more chicken. So the court has said that one state cannot regulate the commerce in another state. That is, it's the role of the federal government to regulate interstate commerce. And this doctrine has a very keen application to the internet, right? So can New Jersey pass a statute which makes it a crime to put a file on the internet in Texas? So I actually argued in New Jersey Chancery Court. New Jersey argued, I'm not joking you, that putting a file on the internet in Texas was a nuisance, a common law nuisance. The same way if your neighbor is playing loud music at night. New Jersey said that because a file is put on a Texas internet server and it can be downloaded in New Jersey, that can trickle down and create harm in New Jersey. It's a common law nuisance. And I argued to the judge, dormant commerce clause, right? One state cannot regulate the internet commerce in another state. He actually thought I was wrong. I also told him, Judge, a chancery court can issue a nationwide injunction. I don't think it was personal jurisdiction, but as a general matter, states can't regulate the internet. Now, your state's tried. California has these sort of do not be forgot, the right to be forgotten laws, and you have to order deletion on the internet, and even these revenge porn statutes are trickling through the courts now. To the extent that any branch of government can restrict the export of arms, I think it's Congress. And I think the federal government may have some role to regulate internet exports. I'll maybe talk with Eugene what those are, but I don't think a state can do it because of the Dormant Commerce Clause. There's also the related issue of preemption. You may know about the Communications Decency Act, which was a very important statute from the 1990s. And it says if you are a host of information, a state can't hold you liable under state law for hosting information if you follow certain procedures which aren't really relevant here. This statute imposes strict criminal liability for sharing a file or even hosting a file someone else shares. There's no mens rea requirement. It's a strict liability offense, so the procedural things don't even play into it. So I think there are significant problems both in the Dormant Commerce Clause and on preemption with the states trying to regulate the internet in this fashion.
All right, so let me just add one of my favorite lines, some of you may have heard me use it, is a law is the only discipline in which the phrase "that's an original idea" is a pejorative. So there's nothing at all original about Josh's ideas here as to the Commerce Clause. This, in fact, was the theory on which many courts struck down state laws that banned the distribution of sexually themed material online. Some back in the 1990s. State state legislature passed statutes that banned the distribution of so-called obscene as to minors material that isn't fully obscene, but that is considered unsuitable for minors. They prohibited distributing it online in places where minors could access it, so essentially there weren't paywall. And courts pretty much uniformly struck those down, precisely on Dormant Commerce Clause grounds. Then eventually Congress tried to do the same, and then in Ashcroft v. ACLU, that was struck down on First Amendment grounds. So that kind of cut off that set of mooted sort of the Commerce Clause issue as to those kinds of laws. But this is indeed a very plausible theory, and of course it's understandable that a state would say, look, if somebody is posting things online that might be downloaded in our state, might cause harm in our state, we want to prevent that. But it's just not clear that the state has the power to do that, and that the standard response is if you think there are these interstate harms happening, you have to go to Congress, and you have to get Congress to try to get this taken down rather than doing it yourself. An interesting twist that I think is coming up a little bit is to what extent do developments on the internet having to do with geolocation make permissible what was once not permitted? So the theory would be, we in New Jersey, we acknowledge we can't just sort of say you can't post anything online that might be accessible in New Jersey, because that would interfere with things posted in California just for the benefit of other Californians. But we can at least insist that you check to see if it's being accessed from New Jersey. Not a perfect thing, of course, because people can spoof their location, but still, we'll settle for 90% compliance. So what do you think? If the statute were written that way?
I tried that argument. So over the summer...
I thought they would try that argument rather than
No, we tried to mitigate an injunction.
So, I see.
So over the summer, in the span of about 3 days, we were sued in Texas, Pennsylvania, New Jersey, and in Seattle. I actually had to argue a TRO hearing on about 30 minutes notice. The judge came in on a Sunday and said, I want to have a TRO hearing now. I argued the case from LaGuardia United Lounge, which is probably the worst airport in the United States. I was sitting in the lounge doing a TRO hearing by phone. And I could sense that this case might not come in my favor. So, Judge, I'll tell you what. We can block all IP addresses from Pennsylvania. And we will do this voluntarily to moot the TRO as a way to just preserve the status quo. So we didn't actually care about Pennsylvania. We just didn't want to take down the website. And the judge said, fine, on your representation that you'll block Pennsylvania IP addresses, I will deny the TRO. We'll come back for PI hearing at some point in the future. So I consider that actually a victory.
Right.
From my perspective, because it doesn't matter. The next day I had a hearing with New Jersey Chancery Court. And New Jersey Chancery Court said, well, Your Honor, we have our expert who said if you have a mobile IP address in Newark and you connect to a New York cell phone tower, you can evade it, or if you have a VPN. And said, Judge, this is more or less a 97% solution. And the judge says, well, that's not really good enough for me.
Got it.
But he eventually denied the TRO on grounds that are somewhat complicated. But I made that exact representation. Let me make a point. This is North Korea level stuff, though, right? No one had ever actually tried blocking stuff on a state-by-state basis. Cody and our tech guys, they had to scramble and actually make up an entire new protocol to block on a state-by-state basis. It's never been done before. You do countrywide basis, right? That's fairly common for IP and otherwise. But we just never had a situation where we had to block a state from accessing information. So we were the first to do this. I actually call it our blue wall. We built a blue wall in around 20 states, all the basic blue Democratic attorney generals. You can't access it from those states. We were able to graph with a little blue wall. It's kind of cute. But we had to innovate a little bit with technology to actually do what Eugene proposed. We
Got it.
scrambled that.
Got it. So that's the interesting Commerce Clause question. Let's turn to the First Amendment question,
Yeah.
because I think for many people, sort of their first reaction is this kind of a strange thing for the First Amendment. They could sort of see Second Amendment, but where's the First Amendment issue here?
Sure. So before our case even came around, there's been a lot of litigation. Is code speech? And this is an issue that I think reasonable minds can differ on. In fact, Eugene and I probably do differ on it. But a number of courts have actually held that certain types of source code are protected speech. And they've drawn the line between code that requires the intersection of the human mind, that is, you actually have to do stuff to it, you have to edit it, you have to moderate it, versus something where you just press a button and it runs automatically. Think of like an executable file in Windows, right? Versus, you can have a HTML file or maybe even a Photoshop file or a CAD file. We've argued throughout the litigation that the files we have fall closer to the expressive stuff than the automatic stuff. And I can just give you a very brief summary of how this technology. Has anyone ever done 3D printing? Okay, good. Oh, so some of you may have actually done this, right? You start with something called a CAD file, right? And a CAD file is a way of representing a three-dimensional object, like a bottle or something, on your screen. You can view it visually or in code. You can say, this is a cylinder with a radius of 3 inches and a height of 5 inches, and the cap is this many inches, whatever it is. This is information that you explain on a computer. To actually turn a CAD file into a file that can be printed is a process called slicing, which is fairly cumbersome. It requires a lot of judgment calls, right? What kind of materials you want to use, what kind of thickness you want to use, what are the dimensions, what are the proportions. There are a lot of actually fairly tough decisions that go into how to print something. It's not just point, click, shoot. And we've argued that this sort of information does have a lot of expressive content, and it falls within, I think, the ambit of the First Amendment. And if it does fall within the ambit of the First Amendment, then we have to ask, is it a content-based restriction? And we think it does. I'll use New Jersey's law as a model. I think it's very clear what it's doing. But it makes it a crime to put on the internet. I'll read the quote. Digital instructions in the form of computer-aided design files or other code or instructions stored and displayed in electronic format as a digital model that may be used to program a three-dimensional printer to manufacture or produce a firearm receiver, magazine, or firearm component. That's a very broad statute which sweeps in a lot of speech, and I'll just focus on one part. Firearm component, that can include like a nut or a bolt or a screw. So we have serious overbreadth problems, but even if we don't have that, I still think we have a content-based restriction based on how they've defined what exactly they're prohibiting. We don't think this is conduct, right? We're not saying that you have a right to print the gun, and we're very careful about this. We've never actually argued that we have a constitutional right to print or even possess the gun. We've only saved the right to share the information. And in fact, most people who download these files never print it, right? They've been displayed in art galleries, such as, graphical designs, right? Engineering students study these. These are actually a lot of value aside from making the gun. So that's the basic First Amendment argument in a nutshell.
Got it. So it's interesting, again, this is something that has come up before, in particular with regard to decryption software.
Yeah.
And in fact, there had been, I think, a victory against the export
Bernstein,
restrictions back in the late 1990s, back when the government was trying really hard to restrain the distribution of encryption software. There was a victory on First Amendment grounds there. So I've always been quite intrigued by this, and I do agree. So I've seen these files, and it's true, you can take the file, it's not just like machine code, you can take the file and you can visually see it on your computer screen. Likewise with source code. I used to be a computer programmer, that was my first career. Source code is very expressive and communicative, and in fact, one way that people often teach algorithms and explain how to do certain things with computers is by showing the source code. And then people don't just enter it into the computer, people look at it and they learn from it. So I totally understand that. But here's what strikes me as a complicated problem here. So let's look at a different kind of medium that most people would agree is protected by the First Amendment in the sense it can be expressive, and that is sculpture, right? The fact that something is not in words, but is a three-dimensional object that is made of various material, could be wood, could be stone, could be metal, doesn't strip it of First Amendment protection. Or put another way, it's certainly possible for it to have First Amendment protection. And if I take a piece of metal and display it in an art gallery, well, and the government says we don't like its look, we don't like the message it sends, clearly you can't do that. But let's say the piece of metal is a piece of metal which is very sharp, and in fact it's sort of shaped like a knife, and I decide to carry it on my person. Now, it's set aside for a moment the Second Amendment, where there's a right to carry knives on your person. It's an interesting question, actually. Oregon has some case law suggesting that there is indeed such a right. I think Connecticut or Delaware might too. In any event, but let's set that aside. Let's say it's just a First Amendment question. Let's say somebody stops me for carrying a knife, and I say, no, 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 no. I am possessing and displaying, let's say I'm openly carrying, I'm displaying the sculpture of a knife. It happens to be a very sharp sculpture. And look, if we put it in an art gallery, people would say, oh, sure, it's art, because anything in an art gallery these days certainly is art. I think one possible answer might be that that whatever restraints there may be on the government suppressing it because of what it conveys, what it says, maybe even because it looks frightening, maybe. If the government is constraining it because of what it does, or, as with a knife, what it can do, because in a holster on my belt, the knife does nothing. It's just what it could do if I were to take it out and stab someone with it. Then that's not a speech restriction anymore. And to the extent there is any First Amendment right there, it's only subject to this O'Brien, U.S. v. O'Brien intermediate scrutiny. So first of all, would you agree that my claim that this ban on knife carrying it would violate the First Amendment, if I were to raise that claim would lose because the knife is being regulated because of what it does and not what it communicates to a human? And if you do agree, then the question is, let's say there's a law that basically says you cannot distribute material that when inserted into, or when fed into somehow, downloaded into a 3D printer, would generate a gun. That too is a restriction, not because of what it communicates, but what it does.
Right. I've said as much in court. I think the government could possibly draft a very narrowly tailored statute that prohibits the use of certain types of code that could be used to make prohibited designs. When I say very narrowly tailored, I think it has to be. At a minimum, I think you need some sort of intent requirement, right? Merely posting information on the internet as a way of teaching people about something, I don't think cuts it. Holder versus HLP and a few other cases discuss the intent requirement. Also, I think you need to have, the key word is integral. There's an old case called Gibney, which discusses crime that's integral to speech. And I view the word integral as very important. You have to have a very close fit between what the person's doing and the prescribed criminal conduct. And I said as much to the judge. Eugene's not pinning as something novel. I think you could possibly craft a statute that's precise enough that doesn't have overbreadth problems and has the right intent requirement. The New Jersey statute's not even close. It means a content-based restriction.
Well, but I'm sorry. So if I could just probe a little bit of that. So I can see how you might say that this restriction is content neutral, but is still too broad. But how is it the lack of an intent requirement makes it content-based?
No. The separate elements.
Oh, I see.
I think to actually survive the requisite scrutiny, assuming you have a narrowly tailored statute, you need to prove the mens rea that the person actually shared this code with the requisite intent to use it in some sort of criminal fashion.
But why would that be so? Because let's say, so for example, if I'm carrying my knife, and I say I don't have the intent to use it against anyone. Mm-hmm. Some states actually prohibit only the carrying of knives with a bad intent, but others do not. And I take it that doesn't make the law into a content-based law, nor does it make it overbroad with respect to those people who want to carry a knife for expressive purposes. I might want to carry a knife for expressive purposes because that's my way of showing support for knife rights. But I take it the government's view is this is something that is potentially dangerous, and we can restrict it because of this potential of the danger.
Uh-huh.
Even if you might not have the intent to use it illegally, maybe you might develop that intent later when you get angry, maybe somebody might grab it from you, maybe it's just too hard for us to prove intent, but usually for content neutral restrictions, they don't have to be limited to things done, content neutral restrictions on conduct, to things done with a bad intent. They could apply to things done that could lead to bad results.
So again, it's a question of fit. If I have a knife in my holster, it takes me about 3 seconds to kill someone with it. Stab. If I have a USB drive, it will take me about a week to create this weapon. There's a lot of work that goes into it. If you want to talk about Brandenburg, imminent harm, right? There's so much attenuation between actually putting this file online and using it to create a deadly weapon that I think the state needs a greater interest, which is why I think the knife example is distinguishable, right? Merely putting the file on the internet for others to study is a very different act than keeping a knife on your side that may be used to inflict harm right away. I think there's a very big degree, a difference in degree as well.
So, so I see Brandenburg as something that cares a lot about imminence, but that has to do with testing restrictions that are content-based restrictions on advocacy of crime. Let's say there was something that I would possess that might cause harm at some particular point. Let's say that I put up a sculpture in my front lawn, but that sculpture is a parabolic mirror. Nothing says you can't have a sculpture with a parabolic mirror. It could actually be quite a beautiful sculpture. I'm sure there are some sculptures that are that way. But it turns out my neighbor happens to figure out that at some point, when the sun hits it just the right way, it's going to focus the sun's rays on his house. And it's not going to happen right away. It's going to happen sometime later on. Maybe it's even some parabolic mirror sundial sculpture that's really set up so it's only on May 3rd at 7:15 in the morning that it's going to happen. So it's a weird hypo, but it's something you could certainly imagine it's happening. And you can talk about all sorts of things about what the right way of regulating this is, but I would assume that there's no First Amendment problem with a government saying, because we think at some point it is, or let's say it's not even that it's certain to be used this way. Usually I'm directing it in a way that's not going to damage anybody. But there are a bunch of prankster kids around the neighborhood that have been known to move it around. And the neighbor says at some point they might come and they might move it. So it points it at my house. So that actually avoids the May 3rd thing. Just at some point it might happen. And various code enforcement people or whatever come to me and say, we don't care what it looks like. Don't care about its sculptural quality. We care that somebody can move it in some place that's going to burn down your neighbor's house. Is that a First Amendment problem if they demand that I take it down?
Well,
because remember, my intentions are pure. It's just that these kids.
well, let me make this point. The New Jersey statute, I keep coming back to this, the law we actually have, makes it a crime if you share information that may be used by others to commit a gun. So I gave this example to a
Right.
judge.
Just like
I gave the judge some hypothetical.
Yeah.
What if I put online code that makes an operable firearm, right? It's used for a video game, right? It's just a design for a gun in a video game. I think we'd all agree that's protected. And then someone says, oh, that's great. Let me make some modifications to this code, tweak it so that it is a functional firearm. I had no intent. I had no knowledge of this. The New Jersey statute then imposed liability. So your prankster hypo is actually similar to a hypo I gave to the judge in court a few weeks ago. And I said, you need something greater for protected speech, right? If we agree that the non-operable firearm in a video game is protected, and then someone tweaks it such that it can be used to actually make a gun, you need a greater intent requirement. You need something more so that I can be held liable for bringing this initial file on the internet in the first instance, right? The act of third parties, derivative down the road, are not enough. And you have cases like Playboy and others that you need more of the conjecture. You need something a lot more concrete. Imminent might not be the right word, but something more concrete now to justify a prior restraint. Again, they've actually started an injunction against us. Eugene and I were talking about injunctions at lunch. This is not merely can you punish us after the fact. New Jersey started an injunction against us to stop posting information ex ante. Right? We can't put online in the future, which I think is different than if we put online and someone does download this gun, and someone does make a gun out of it, can you then prosecute us? I think that's actually might be a different standard. We have a prior restraint here we're challenging.
Well, so, again, prior restraint is something that's easy to use that label in court if it's a content-based restriction. But again, here, I think the government's claim is that what they're worried about is what it does and what others can do with it, not what they can communicate with. So let me just close with probing once more on the parabolic mirror, and then
Okay.
there'll be plenty of time for
Yes.
for questions from everyone else. So let's try to have a more concrete story on my parabolic mirror. So I have it on my front lawn. It is actually not pointed towards a neighbor's house because I'm a good guy. That's not my intention. But in fact, people have been known to turn it around, and I tend to usually, when I get a chance, reorient it, but it's certainly possible that it's going to do that. Maybe there's been a close call. And then the city, maybe it's the fire department or whatever, the fire marshal, seeks a public nuisance injunction against me, also an injunction, and says, you know, we want Volokh to take this down so that people can't then turn it around. And I say, well, this is a prior restraint on speech. And he says, I don't care what you're saying with it. I don't care what you're communicating with it. What I care is that somebody, not you, not with your intention, but still somebody could take it and use it to burn someone's house down. Just tell me if you think that's a First Amendment violation and if you think that that's a prior restraint. And then we'll see what others have to say.
So let me make sure I understand hypothetical. So the government seeks a nuisance injunction because it's possible that some neighbors may alter the mirror and that the homeowner may not be responsible enough to
There's
move it
a
back.
mirror on the front lawn, and it's not a matter of alter. They just need to turn it. I usually have it pointed to a safe direction, but if they turn it, and again, it's similar things have happened elsewhere. Let's say.
I think in terms of the free speech,
Yeah.
you would need a more narrowly tailored injunction to bar people from entering that property and people who be held in criminal contempt for trespass. I think there are
But it's
far more narrowly
that's not gonna
tailored.
work is the problem.
But
Because
you're
they're
saying
gonna keep
remove-
trespassing,
right?
right?
But you're asking to the
Yeah.
problem is you want to remove the parabolic mode of burning houses down. There's a more narrowly tailored way of accomplishing that.
It's just not going to be
than
effective.
removing it.
It's going to be a totally
Yeah.
ineffective but narrowly tailored means.
I think it'd be effective if you prevent people from accessing the mirror, or you
Uh,
make it in such a way that can't be altered. In other words,
So the injunction orders me to put up a high fence.
something else short of removing it,
Uh-huh.
which might diminish the aesthetic value. But in other words, with First Amendment stuff, right? You guys learned this in class. What would have been more narrowly tailored approach look like? I concede to open court that Congress, not a state, I think the state can't do this, but Congress could possibly draft something similar to if you put this code online in such a direct fashion with the intent, et cetera, it probably could pass scrutiny. I would tell this to any judge in the world, because I'm not going to be an idiot and say you can't ban any of this stuff. But I think you need to have narrow tailoring, and a statute we have in New Jersey, I think goes too far.
All right, so.
Thank you, Jude. Good. I feel like a student now. It's like a cold call for an hour straight. Man, I should be standing up Socratic style, right? You want?
We don't do that anymore.
You don't stand up here, UCLA?
No, we also don't use we find we don't use the authentic Socratic method.
No.
Because the authentic Socratic method, is you ask people really hard questions and then they kill you.
Who has the first question? Eugene won't murder me. There are no guns allowed here.
Yes.
So I think we were starting to get to it, but perhaps another response to your hypothetical maybe would be that Professor Volokh.
No.
And Josh, please.
Josh.
Please.
Yeah.
By the way, when I first started teaching, I asked Eugene about this. He said, let your students call you first name. I was like, I agree. And I tell my students, call me Josh, and none of them do it.
Right. That's
It's different. But
yeah.
Eugene told me this several years ago, so I'm grateful for that advice.
So, Josh, perhaps a better response could be that it would be overbroad in that the city could simply tell you that you have to fix the parabolic mirror so that it couldn't be moved. And then if there were to be a case where the neighborhood kids came and broke your sculpture such that it was moved to cause this, then I don't think the city would be able to come back to you and say it was a problem, or maybe they would, and then it would be then incumbent on you to identify the people who did move it to sort of almost like a third-party liability.
So I think there are all sorts of reasons why it may be not a very good idea, or not just to hold people liable for what other people do badly with the stuff that they've that they make available. I'm just not sure that's a First Amendment argument. I'm not sure that I have that any First Amendment objection to the city saying, look, the only really effective way of keeping kids from playing pranks in with this mirror is to get it taken down. It just doesn't seem to me to be enough of a speech restriction to justify it.
Remember the attractive nuisance doctrine in
Yes,
courts? It
yes,
sounds
exactly.
similar to that.
Exactly. But attractive nuisance doctrine is also a controversial doctrine, to be sure. But it's a matter. The boundaries are put as a matter of kind of substantive tort law. But if a legislature, especially if Congress, wants to be even more demanding and more restrictive of people, innocent people, because of how people might misuse their products, there's generally not a First Amendment problem.
So if the posted code, let's say, was missing a bracket or a comma to one coding class, but like there's something wrong with the code, but very minor, like a one character difference or two character difference, such that someone who uses the code, they use their 3D printer, everything else they know doesn't work.
Yeah, they have to modify.
They have to modify it in some way, even if it's just like period in one place. So they have to read through the source code to figure out where that goes. What happens?
Yeah, I think Eugene and I had a conversation over the summer. One of the difficulties with narrow tailoring on this is how do you define it? Now, New Jersey defined their statute based on what the end product looks like, that it may be used to manufacture guns. I don't know if you can draft a statute saying that here's what the source code characteristics have to have. So when you define it based on the end product, that sounds more content-based. Your hypothetical, I think, is good because it's not just point, click, shoot. It's point, compile, debug. You have to find the bugs in the code in the compiling process, which it can be very time-consuming. It can be a lot of work. And Eugene, what do you think of that question?
Right. Well, I think the compile is something of a red herring. I mean, compilation is an automated process, and obviously there's a lot of code that is interpreted rather than compiled. So, I'm inclined to say that again, if the government's concern is that this information that it would be used directly to feed into the computer, even with some fairly mechanical modifications, I think that still would be a conduct restriction. But there's no doubt that this is indeed closely abutting on the manual problem. Let's imagine that there is a handbook on how to machine guns. I mean, there are lots of, I'm sorry, machine guns sounds strange.
How to machine a gun, yeah.
Exactly, how to create guns, how to actually make a gun as a gunsmith. It's a gunsmith textbook. There, of course, are those. How do you think gunsmiths learn that? And obviously, people use those in order to create guns. That's got to be protected by the First Amendment. A restriction on the distribution of that kind of manual, I totally agree, has to be protected by the First Amendment. The question is, when does it stop being an instruction for humans and becomes a device? Essentially, a device that is basically a software device rather than a hardware. Let me ask you this question. Imagine that instead of code, this was a physical thing, that the way 3D printers worked is instead of giving them code, and it would be a pretty bad design, but imagine that this is so. You had to give them like a little piece of metal with stuff in it. And you put it on and then out comes this. I take it we'd say that regulations on those pieces of metal, limiting the sale of those pieces of metal, would not be First Amendment problems.
Yeah.
And that's so even if people know that the piece of metal that is sold doesn't by itself do anything, you need to bend this wire and bend this wire to do that.
I wrote a paper years ago called What Happens If Data is Speech, and I addressed a very similar hypothetical. So let's start with the series of hypos. First, I take a paintbrush and I go like this, right? Speech, no one doubts it, right? I decide to use Photoshop and I use a stylus instead of a paintbrush. I think that's speech. Right? Now I say, Siri, draw me a painting. And Siri mechanically grabs a paintbrush and draws it. That, I think, moves away from the First Amendment. Right? And now I have an app that just knows what I like to, knows what I like and just, without me prompting, spits paint on a canvas, right? Because it knows what I like based on my preferences. That's not. So I think you have a spectrum, a gradient. So the automatic thingy Eugene described, I think it's closer to the computer just knows I like this and spits paint on a canvas, based on what my tastes are. I'm okay with saying that sort of code is not protected. But where we are today, at least, the code being used for 3D printing, and it hasn't changed much in the 5 years I'm in this case, there's a lot of human interaction that goes on to go from the code to the actual end product. It's not the automated thingy. So again,
But why would there be human interaction? Why doesn't somebody write a program that does all of that interaction?
I've asked this question of Cody. It can't be done. There are a lot of judgment calls of how to print that still require people to make decisions how things work. The slicing process is actually fairly labor intensive. I'm not a mechanic. I don't do this stuff myself. I've never actually 3D printed on my own. Maybe I should. I don't know. But I've talked to people, and there's still a lot of work that goes into it. You know, for example, a film crew came by the Defense Distributed Lab and said, hey, can you guys 3D print a Liberator? We want to put it on camera. And they said, it'll take us 40 hours to do. And this is a company that's been doing this for years. It'll take them a full work week to actually make all the parts for this gun. There's a lot of work that goes into it.
I'm sorry, so there's 40 hours of labor or 40 hours because you gotta wait for the machine to
Both. There's a lot of tech stuff that goes into it, plus the printing. So there's a lot of work that goes into it.
Got it.
But good question. Thank you. Yes.
So on your earlier hypo about the knife that someone
Yeah.
carries,
Yeah.
right? So then, at that point, I think it becomes quite obvious that this isn't a First Amendment issue, and that it becomes an issue, of safety, and the government can legitimately regulate it. But there are so many other things with like sharp objects, so many other things that could potentially be used as a
Right.
part of a firearm. What prevents, say, the government from restricting protest signs because they look at that and they go, oh, well, you could actually beat someone to death over the
Right.
head with that.
Like a CUNY. Yeah.
Yeah, and then what differentiates the person who carries the
Right.
knife on their
Right.
waist to say, I'm in favor of knife rights, versus the person that carries the sign and protests saying, I'm in favor of whatever it is the sign talks about.
So it's funny you should say that. There are ordinances that actually limit the size, the thickness of sticks and the kinds of sticks you use for signs. I think LA may have one of them. There are many such ordinances, precisely because, you know, a picket, you don't talk about picket signs, the signs on little pieces of wood. Well, that could be a club just as much as a sign. So it's true that that would be viewed as subject to First Amendment scrutiny, but as a content neutral restriction, right? And there would be a sense that even as a content neutral restriction, if the restriction is essentially you can't carry anything at a protest that could be used to hit anyone over the head with. You can only carry pieces of paper. Court might say that doesn't leave open ample alternative channels because it's really hard to hold up a sign without something to hold it on. So there would be a narrow tailoring requirement. But I'm not inclined to say that would be so with regard to, say, carrying a knife. Like, well, you've got to have the right to carry some knife to convey your message. And it's an interesting question, why not? Maybe it's that carrying signs on sticks is such a traditionally recognized right that it's more protected than just carrying a knife for symbolic purposes. But it seems to me that as a First Amendment matter, if what you're worried about really, it's nothing to do with what you're communicating and simply with what the physical quality of that thing is, then the protection is going to be very modest. Yeah.
So, at what point do we stop if you can just create content neutral restrictions that are facially content neutral, even though you have your own back reasons for doing so,
Right.
and then just using it to restrict certain speech? So let's say there's a sculptor who's politically controversial,
Right.
whose sculptures are about yay high, and at the bottom they have a nice round base, and they're quite stiff, and in fact they kind of look almost exactly like a club, except the handle maybe is
Right.
in the shape of a person. You're the government, you don't like it, and you say, okay, I'm not going to go and restrict this person's speech and these sculptures, even though that's what I want to do. I'm just going to say that you could use the sculpture and beat someone over the head
Right.
with it, and we can get rid of the sculptures altogether.
Right. So I think there are a couple of things going on there. One is, to what extent should should courts look behind the face of the statute to discern legislative or other governmental motive? And that's an interesting question. U.S. v. O'Brien talks about Cornelius v. NAACP, Legal Defense and Education Fund, Reed v. Town of Gilbert, and there is the sense that some degree of scrutiny of what is the true motive is relevant. But the other general protection is that what you're talking about won't happen because people love to play baseball, right? That one protection against these kinds of content neutral restrictions is the political process, that the most aggressive ones never get enacted because too many people say, well, I happen to have things that look like that. It's just a baseball bat, and if you outlaw those things, then you'll be outlawing my baseball bat. So as a practical matter, actually, I just don't think that's likely to happen, and it hasn't happened. And in the case of the 3D printed guns, my sense is that, I mean, I'm not generally a supporter of gun control laws, but my sense is that the people who are trying to ban the 3D printed guns, they're not worried that it's going to spread a message of gun rights. They're worried that people will actually print guns and actually use guns for non-communicative purposes. I don't think that that ill motivation is the issue, or at least speech-restricted motivation is the issue.
In the back, I'll pick one point. When the Attorney General and Governor, when they were signing this bill, they mentioned our clients by name.
Right.
They mentioned it by name as they're saying, we want to stop them.
Right, but not because he's a gun rights supporter, not because we think he's going to contribute a lot of money to the NRA. It's because we think that he's going to develop these, what they view as devices that can be used for these harmful purposes.
In the back.
Good, Jenny?
We touched a little bit on my question already, but I guess I'm having a lot of trouble seeing how this is different or more dangerous than like how to make a pressure cooker bomb. I think it almost seems like that requires even less sort of independent human skill or expertise. Like how much of this do you think is just
We argue with the Anarchist Cookbook, we
Right.
argue these different things. To make a pressure cooker bomb like the guy is the Boston Marathon, right? It's a lot easier than 3D printing a gun. It's a hell of a lot more lethal as well. We think these are easy cases. We don't think, we think given the stature they have and the amount of work that goes into it, these are easy cases. Maybe in the future, if we get to the point where Eugene has a magic device, boom, and a gun just pops out magically, I think the first analysis will be quite different. But we have today the amount of effort that goes into making these guns, the instructions, the coding, I'll give you an example. Plastic is a bad material for a gun. Why? When plastic gets hot, it melts. When plastic gets cold, it freezes and basically cracks, right? When you pull a trigger and you put a bullet through a plastic barrel, it's going to explode in your hand. You actually have to treat this plastic with this acetone bath to strengthen it enough to actually to withstand the combustion. And if you don't do it right, you'll kill yourself because you'll blow up basically a bullet in your hand. Right? These are not good guns, and very people actually make them. So again, the pressure cooker is a hell of a lot more lethal, and a lot fewer steps.
like there are lots of guns that are legal that are probably more dangerous than a lot of guns that are banned, but
Yeah.
states generally sort of turn a blind eye to it because they're so
It looks
cost
scary.
prohibitive and
Yeah.
difficult
Yeah.
to obtain that it's just not worth the regulatory time. So I guess I just don't like
Well, part of it is there's a fear of unregistered firearms, and that's actually a lot of the fear, that you'll have these guns that can't be manufactured. Let me tell you something. If I take you to Home Depot and I buy $5 worth of parts, I can make a rifle. If I buy a piece of rubber tubing, I have a rifle. It's not hard to make an unregistered gun. I think a lot of it is just paranoia, right? People get very afraid by these plastic guns. When I was arguing this over the summer, I was bombarded by hundreds of reporters who were panicked out of everything about this. Now look, we put the files online. They were online for about 4 days. They're everywhere. You can Google them. Codeisfreespeech.com. Just go. You can find it. It's very easy, right? It's not hard to find these files, and nothing's happened. And I don't mean to diminish the state's concerns and the state has a thing, but this is I think just a wedge issue that is politically salient. It's not. This is not what you're afraid of if you're waking up at night.
Right. So yeah, I totally agree that the manuals, the instruction manuals may in fact be much more dangerous because among other things you also have instruction manuals for devices that are very
What the
dangerous.
Hitman manual? Remember that the
Right.
Hitman book?
Right. So this is the was called How to Do It by
Yeah.
Rex Ferrell. That was, and it was a manual on how to be a hitman. My guess is that there were probably 30,000 copies, I think, if I recall, maybe 13, maybe 30. In any case, that many copies that were sold. My guess is that very few of them people actually used to become hitmen. And conversely, my sense is that most hitmen learn their trade not by reading Rex Ferrell. This having been said, the Fourth Circuit did allow a case to go forward against Paladin Press on the theory that the plaintiff was claiming that they had the specific purpose of causing people to commit contract killings, which I think is just hard to see what evidence there would be of their purpose. Their purpose was to make money, chiefly selling to kind of armchair soldiers of fortune. But in any case, I've actually criticized that opinion. I do think that publishing that kind of book, even with the culpable intent, should be constitutionally protected. So again, the question becomes when an instruction manual is where the line is between an instruction manual and something that is kind of a device for building something. And it may be a device for building not the final thing, but just building the parts that would then need to be assembled and treated in various ways. But when is it something that becomes a device? And I think that's the real question.
First time, yeah, right here.
This will be a really simple question, but to me it's pretty compelling. I know that code
Uh-huh.
is speech. Mine's very narrative. What poetry. But do you think that the issue here is that people who are making the First Amendment argument are just concerned that if they fail an argument, the Second Amendment jurisprudence is so in their minds against them that this is like their only shot? Is that what you think the impulse is? And I know it's a yes or no question.
Yeah, I mean, so our complaint raises a Second Amendment issue. Our preliminary injunction motion doesn't. Our PI, preliminary injunction, has only been on the First Amendment grounds as well as the Dormant Commerce Clause and the Communications Decency Act. We have not asserted a right to actually print the gun or even possess the gun. We've never made that argument. What we have argued is a hybrid right. So you remember the case of Employment Division versus Smith. Justice Scalia says that sometimes when one right reinforces the other, they require greater scrutiny. So we're actually talking about how to make firearms, right? Talking about how to exercise the Second Amendment. I think the scrutiny is even greater. So use an example. Government passes a law, makes it a crime to publish a book of how to perform an abortion, right? I think you have two constitutional rights, perhaps in one in one package. Or the government, makes it a crime to publish books about how to build a printing press, or I don't know. You can make up your own examples. So I think the fact that guns are in here makes the case stronger for us, but we're not hanging entirely on the Sandlin Second Amendment claim.
Yeah, I mean, the Second Amendment does secure a right to keep and bear arms. It doesn't secure a right to manufacture. So probably what courts.
I don't know about that.
So probably what courts would say, it seems to me, is the question is to what extent does any restriction on manufacturing burden the right to keep and bear arms?
Yes.
So yes, if there's a total ban on manufacturing, that would be clearly unconstitutional because it would keep people from getting the guns. But if it's merely a rule that says you can't manufacture in these particular ways, then incidentally the abortion cases are quite similar, that they generally say that, we don't look to the abortion provider's rights to perform an abortion and in the ways that he prefers. We look to whether it interferes with a woman's right to get an abortion. So yeah, I think it's pretty unlikely the Second Amendment argument would go far. But indeed, your rationale would apply just as much to any attempt to regulate anything by restricting 3D, I guess, CAD files for it. So the logic of your argument would apply to cases far removed from the right to bear arms, I would think.
Yeah. I mean, printing other stuff too. I mean, we actually put this argument brief. What if we want to 3D print a sex toy, right? We actually had this in our Fifth Circuit brief that if the government says to make nice with Saudi Arabia, they don't like having all this immorality, we're going to just ban putting on the internet files to 3D print sex toys.
Right.
That's one of the hypos we raised in one of our briefs.
Yeah, I'm inclined to say that would be a horrible intrusion on people's rights and people's fun. But I'm not sure that's a First Amendment problem. So yes.
So this might be a little awkward, but I was actually the Seattle Judge extern for this.
Oh, I
boy.
thought you were going to say really
Were you
awkward
there?
because you're going to
Were you
start
there?
talking to us about sex
Were you there
toys.
when I argued the case by phone?
Yeah, so I was actually in the courtroom and I could hear you over the loudspeaker.
Uh-huh.
And so I can't speak for the judge, obviously, but I was involved in the discussions and deciding the injunction. And I think for us, or from what I understood, it boiled down to.
I'm sorry, you probably shouldn't be saying this unless,
I
unless you're completely sure that nothing you say
Yeah,
reflects in any way
probably.
the views of
It's okay.
either the judge or.
Yeah, let me just
Okay.
preface
All
this.
right.
This is not from what he told me about
Okay.
his feelings. This was my interpretation.
Just your own personal. Okay.
Right, so this is from what I got from the order that was published
Uh-huh.
online, and it was all, so, from my understanding, it was that the guns were untraceable and there were no serial numbers. I think we touched on this a little bit, but also that, like, when you 3D print these guns, the printing itself is harder to catch than it is the instructions, and I think we've talked about this a little bit, and when can the court prioritize the ease at which, there's a stage at which it's easier to catch these things?
Yeah, so there's a case, was it Bartnicki versus Vopper, right? Where generally when you have free speech, you ban the end criminal act, not the speech used to get there, right? So I think, again, with free speech, you have to take sometimes a less effective method that's more protective of free speech. And just, I'll mention the Seattle case. I argued that on my phone, and if you ever argued a motion by phone, it sucks. And
Yeah.
I had trouble hearing everything, and I hope I sounded okay in the court. I hope the audio sounded fine, but it's very frustrating. And let me make this other point. You always hear about, 25 states sue the federal government with a nationwide injunction, right? And the court held a hearing 2 days later. Right, when you're a state AG and you have 100 lawyers in your staff, that's no big deal. It was me and like 1 or 2 other lawyers doing this entire thing. I worked 90 hours in 5 days on this, right? I was basically up all night writing briefs. A brief for New Jersey State Court, no electronic, they want courier delivery, right? A brief for Pennsylvania, a brief for this, a brief for that. It's very significant when 20-something state AGs come at you at once in different fora, seeking emergency injunctive relief. They wanted ex parte relief. The judge did not grant that, which I was grateful for. They could have, but the judge did not give me ex parte relief. So basically, you have this argument up. Now, that argument actually wasn't that bad. Judge Laskin asked me one question, as I recall. He asked me, do you represent all the parties? Which I said, oh, I'm going to lose. So it wasn't much of a surprise. But it's significant when you have these high-profile, politically salient cases that become these cause célèbres. And, we actually had the last laugh. I'll tell you why. So here was the sequence, right? We had this settlement with the government, and we said, okay, we're supposed to finish the settlement on Friday, and then Cody would post the files on Monday, or maybe it was Wednesday, whatever it was, right? A few days later, the Brady campaign sued us, and they tried to block our settlement in Texas. I actually argued that when I got denied. The second we got the settlement and we prevailed, we got the license, I called Cody and said, you post those files now. Don't wait another minute. And we got those files online immediately. We didn't tell anyone. We just posted them online. So I got this lawyer from Pennsylvania who said, we want an ex parte TRO so you can't put these files online. I said, dude, they're online already. We did it. We won. And then in Seattle, judge, they're online already. They're online already. And the judge had this opinion, this stupid line. Sorry, he said, if you're a cybernaut in the info or the dark web, you can find these files. No, they're on Google. Just Google them. They're online. But we had these files online for almost 4 days. 4 days they're online. We won. I mean, we had a victory that can't be unwrung. And their files are still online, everywhere. You can find them very easily. So I still consider this a moral victory, even though I think we lost in the short term. But they couldn't get to us quickly enough. No matter how fast those injunctions were, we still beat them. I'm damn proud of that.
Yes, actually, yeah.
Okay, so if the anarchist cookbook and the Constitutional law instructions are fine, protecting its free speech, right? If we go to the next step and say that someone gives you instructions on how to CNC machine the lower receiver for an AR-15,
Right.
right? Or actually just how to use a drill press and do it,
Right.
And then give you the
There are
measurements.
books that say
That's
exactly
fine
that.
too. But
Absolutely.
then we go to the next stage and we say, okay, what if we convert those instructions into the instructions for a CNC machine, where seems to be no different than just telling someone how to use the drill press, but then you take that and you make it into the code, which is the same instructions
Right.
as the written word, and stick it into
So-
a different method, and suddenly it becomes a device.
So let's pull it from the other end. Let's imagine that somebody creates, and there are no such things now, but at some point, quite likely there will be, a 3D copier.
A
Where basi-
replicator.
A replicator. Yeah,
Yeah.
someone's come up with a word for it. So instead of, in fact, it would be seen as ridiculously inefficient to actually hand make your own gun. So instead, what you do is you sell someone like a gun, well, not like a gun. It is a gun, and then just say, "But I'm not selling it for you to use. I'm selling it for you to copy it." And you might even have somebody says, I'm not going. I'm sorry. So that's a different hypo I was about to say. I take it we'd agree that even though this original seed gun is just a tool for creating a new gun, nonetheless, presumably, again, setting aside the Second Amendment, the First Amendment matter, it seems to me the government is regulating the conduct of manufacturing guns this way by barring you from distributing that original one, rather than the speech of informing people how to make guns. So on one hand, we have the instructions, the manual, the gunsmith's guide, which is constitutionally protected. On the other hand, you've got the distributing of the physical device, which you can then just replicate. Or let's say distributing of a physical machine whose only job it is to print guns. You can imagine somebody, if there is such a thing, we're distributing this machine, there's no speech issue there. So that you're right that the question is where you draw the line there, but you need to answer that in both directions, is what it seems to me. And I think, to me, the distinction is whether it involves informing a human how to do something, which requires that person to think through how to do it,
Yeah.
or whether it involves essentially causing a machine to do something.
I actually more or less agree with that line, and the code we have in our case is on the other end. Is on the there's a lot of human interaction or human intervention, whatever words you want to use. The people got to do stuff, right? This is not just point, click, shoot. It's not just you put in a floppy disk, remember what those things are, right? And you hit execute. It's not like that, or you turn a key and the thing just spits out. We don't have that. I mean, maybe if we get to that point in the technology, I'd be happy to take a different position, but that's not where we are, at least what we have today.
Jenny.
Yeah, I guess I'm just having a little bit of trouble thinking about the manual versus device point, because to me it seems that once you cross the line from manual to device, then it does become a little bit more of a Second Amendment issue than a First Amendment issue, or at least
A right to manufacture, you mean?
issue of a different type, maybe, but like as soon as we acknowledge that it that it does require more, then doesn't the analysis completely change, and then it's issues like, well, do we punish the downloads of a file, or do we punish do we regulate the sort of promotion of the file and publicizing it and putting it out there? I guess if it is a device, then that doesn't necessarily resolve the question, but just seems to invite new questions.
So to me, the question, at least is the content discrimination question, is the government restricting something because of what it says or because of what it does? Now, of course, that's the question as well. How do you operationalize those terms? So if the concern is that the manual informs a person about what to do, if that's the justification, then in that case, that's content-based restriction. But if the concern is that somebody can, without having any understanding of those files, can create things, and those things don't need to be the ultimate gun. It could be the parts of the gun that they then assemble. I don't think the question is whether somebody has to do physical work. But if the concern is about what it does, then I think it's a content-neutral restriction. And here it seems to me the government's worry is about what the machine will do when the code is entered into it, coupled with what humans might then do afterwards, but not with what it communicates to a human being. That, to me, is the important distinction.
Even the assembly point seems like as soon as you add the assembly point, then that's the harm that you're focused on.
Well, again, let's imagine a situation where you have this physical device that builds something, but what it builds is not a gun, in that it builds two pieces that you then have to put together to make a gun. I think that's still a restriction on that device is still a conduct restriction, even though the things that the device produces are not something, require some extra assembly.
Right. For us, though, it's even if you don't agree with us on content neutral, overbreadth does come into play, because these sorts of laws which ban firearm components will ban a lot of parts that are completely innocuous. A screw or a nut or a bolt, which has lots of primary uses that are not at all criminal. So even if we lose on content neutral, I don't think we will, overbreadth still kills in, and the statute is.
But if somebody does decide to ban a particular kind of screw, that could be a really bad law, but it's not a overbroad law in the sense of a First Amendment overbreadth.
But you're sharing information on how to make this part.
But again, I view this as not sharing information about how to make it. I view it as sharing devices that make it, and that the device is software rather than hardware. It doesn't strike me as relevant. But I'm sorry. Let me give you the last word, and then Brad.
I think calling this code a device is inaccurate, and I think we'll have to agree to disagree on this point. There's a lot of work and a lot of human interaction that goes into it that makes it different than the replicator we mentioned.
Got it. Brad.
So if your different code that goes in 3D printed guns and being downloaded and then emits a sound that causes some trouble.
Like in Cuba, right? The hypersonic sounds, yeah.
So I download the code and I choose when there's no device, really, like I'm not creating something, but my conduct, that you could regulate my conduct, but it's the same speech, and it's the same code, I feel like.
I'll give the same answer I gave before. I think when you have expressive content, and you have the expressive content can do something bad, the government sometimes has to take their lumps and ban the derivative, ban the actual emission of the hard sound, and not the actual code used to create it. I would draw the line, and I recognize that makes the government's job a little bit harder, right? Because once you have the 3 plastic files, you can't really find them, right? They're not traceable. I get that. I don't dispute that. I would put the criminal liability further downstream when you have this sort of expressive content.
So I think that's an excellent hypo, and I want to bring up a real world issue that's coming up with this. But also, I do think this is something where I think that in this situation, Josh's solution is right. So you may recall that there was this prosecution. I don't know what the status of it is, of somebody sending a file with some strobe lights.
Oh yeah, Twitter also.
To someone who he knew
Epilepsy.
suffered from epilepsy, and not all epileptics, but some. I think about 3% of people who have epilepsy are strobe sensitive, and it can actually trigger a seizure. So there it seems to me that a restriction, that punishment someone for sending that is a content neutral restriction. Because again, you're not restricting it because it communicates evil messages. It's a situation where, a rare situation where particular kinds of light actually causes physical effects. It's like this story, I don't know how accurate it is, but every so often you hear about the opera singers who can shatter glass by hitting the right note. Well, if you were to regulate that, then presumably it would be a restriction not on the content, but on the physical effects. But I do agree that when we're talking about that, just for practical reasons, nobody's going to say it's illegal to distribute this sound. Because almost inevitably, this sound, just like anything visual, is going to have lots of innocent uses that, as a practical matter, the government isn't going to try to ban. Like, nobody has actually tried to outright ban all distribution of strobe lights because there are too many people who are using strobe lights for dancing and whatever else. But in a sense, it's almost overdetermined because there are all of these political constraints on any bans in the distribution, that the only thing that's going to be banned is the actual misuse. So here I think we don't need a First Amendment. You just, as a practical matter, nobody's going to try to ban something other than misuse.
Okay. Yeah, I'll leave you just with one. I think we're running short on time. Try to think of what a statute would look like that would actually pass relevant scrutiny. I think it's actually harder than it works. The New Jersey one, I think, is actually an easier case because it has a lot of problems. But to the extent that Congress actually thinks this is a serious problem, to draft a narrowly tailored statute that actually meets even, I think, O'Brien, I think would require some work. I think you need something a little bit more specific to pass O'Brien. I argue to the judge, I don't think the statute passes O'Brien or any sort of scrutiny. I think it's way too broad, and it punishes derivative uses that may not even be my intent. So I'll leave you with that.
All right. Josh, thank you very, very much. Very glad you came all the way here.